everybody. It's attorney Laura Sterling, and it's my live show. My live show for the month of May. Can you believe it? May 28th. Boop, this month just went like that. I'm still a little groggy from the Memorial Day weekend, but we're coming around. We're coming around. So I hope you all had a wonderful and safe holiday weekend. Hope you enjoyed time with family and friends, as we always do when we have holiday weekends. So hopefully a lot of you got to spend some relaxation time on Monday and not have to be to work. So here we are in the month of May. What does that mean? We're sliding into summer. Here we've been in Florida. We've been in summer for a few months now. I can't take my dogs out in the middle of the day for long because they're a mess. I'm a mess by the time we get back, sweaty, hot, everything like that. I know the Midwest, kind of down lower by Texas and stuff, have had a lot of tornadoes. Up in Minnesota where my parents are, they've had a lot of rain. Here it's just been hot. That's all I gotta say. It's just been hot. I would love some rain. I would love some rain. My lawn is rough. I would love it. But you're always wanting something else. But anyway, I want to welcome you to my live show. As we discussed, this is kind of my criminal month that I talk about criminal stuff. And then during the summer, I generally touch on that until we get to the end of the summer when school's about to start. Then I slide right into my family law stuff because that's kind of when those issues come up about schooling and stuff. But during the summer, I like to talk about more of the criminal aspect of it because, summer comes, kids are out of school, we're doing more vacations, we're having more parties, we're having barbecues, we're by the pool, we're on the lake. Things tend to happen. So that's why I like to focus this summer on criminal matters. Now, as I always say for my life, remember, I'm an attorney licensed in the state of Florida. That is the only state in the United States that I'm licensed for. I've been thinking about getting licenses elsewhere, but you got to check into that. If I got to take another test, I think I'll fall over. But I'm only licensed in Florida. So when I talk about things, I'm generally talking about things that are in Florida. So if you have a question about something and you're outside of Florida, please, please, please contact an attorney in your state, an attorney that deals with those kind of issues, whether it be criminal, family, estate planning, guardianship, probate, whatever it may be, that you contact an attorney in your area. And a way to find an attorney in your area or to get a great referral is to call the state bar. Like here in Florida, it's the Florida Bar. That's what holds our licenses. That's what oversees us as attorneys. They have a nice referral service that you can always call and get referral services or referrals to other attorneys within the state or within your own state to focus on whatever your issue is. I know I was just talking about this morning that people like to go Google and try to figure out legally what they need to do. But I'm telling you right now, Google is not the answer. You need to speak to a living, breathing person who has a law degree, who practices law, that can tell you how it is. So please make sure that you always talk to an attorney before you turn to the internet and decide what you're going to do from there. So I cannot believe that Saturday is June. Saturday is June. Can you believe it? I'm getting ready. I'm running Grandma's Marathon this year. So for those of you who are runners and know Grandma's Marathon, it has been an Olympic trial in the past. It is not this year. But so I'm going up to do that in northern Minnesota. And so I'm looking forward to that. I'm looking forward to giving you some video on my run, as I always like to do. And it's a beautiful run. It's right by Lake Superior. So it'll be nice and cool, hopefully, and a nice run because, tell you the truth, they don't have any humidity. They think they have humidity. They should come down here to Florida. Anyways, I'm looking forward to that. So I'll keep you posted on my Facebook page of my adventure of running Grandma's Marathon. It'll be my first time. I've never done it before. I've always wanted to do it. I grew up with it, but now I'm finally doing it. So wish me luck. So let's get started. Let me roll up my sleeves. Get comfortable. You all get comfortable. Hopefully you're sitting in a comfortable spot. You've got whatever you need to take notes. Know that we do keep this live on my Facebook page. So if you ever, gosh, what did Miss Sterling ever say about that? You can certainly go through and find it and rerun it again so you can get your questions answered. Or you can simply call our office and I'll be more than happy to explain it to you. So please sit back, relax. Hopefully you've got something to drink. I got my water with me. You got something to maybe nosh on. I haven't had lunch yet, FYI, and I'm going to be going straight through till 5 o'clock. So make sure you're comfortable though. Make sure you're awake. You got the air conditioning or the heat on, whatever you need to, and let's get rolling. Okay. This month, as I promised in all my videos, I'm talking about criminal procedures. Now, when I say criminal procedures, I mean criminal procedures in the state of Florida. Each state has their own procedures that they follow when it comes to criminal cases. And why is that? A lot of times it's to avoid a delay. Now, I know what y'all are thinking. Wait a minute. Remember those Idaho murders? When did they happen? Last summer, I think they happened. I don't recall. It seems like it's been forever. But that keeps going on the news, right? And there's no trial date, no trial date, no trial date, no trial date. The cases they want to move the criminal cases through, I don't want to say quickly because we want to make sure that we get everything done. But depending on the nature of the crime, we want to make sure that the case is moving, that it's moving forward, that it's not just stagnant. And why is that? Because guess what? When things sit stagnant and things don't move and time passes between when the incident happened and when it goes to trial, look at how far. You can't even see my hand anymore, can you? Memories fade. Evidence goes astray. Things happen, like the Idaho murders, how they demolished the house. Whether or not I agree with that, it doesn't matter, but that's evidence. And now they've destroyed evidence. But, time passes. So the reason to have criminal procedures is to dictate the movement of those cases, that we don't just sit on these cases. Oh, well, maybe if I sit, I had a client say to me recently, well, maybe if we wait long enough, then they'll just dismiss the charges. Well, no. Number one, we can't just wait. We can't just what time is it? Let me see if they dismiss the case, or hope that the victim or whoever doesn't want to testify anymore, doesn't want to do that because the cases move. Here in Florida, we have pretrial conferences, case management conferences, docket soundings, trial call, all of those things. So you have to be prepared. You have to do things. You have to ask for a continuance. If the continuance is granted, it's only granted for a certain amount of time. So that's why we have criminal procedures in every state. I don't know what it is in other states, but I do know most of it here in the state of Florida as we practice criminal law. So one thing I wanted to start with is something called speedy trial. Now, what is a speedy trial? Now, it sounds like, doesn't speedy trial sound like, okay, my trial's fast. Let's go, let's go, let's go. It's going to finish. It's quick, it's quick, it's a quick trial. No. Slow it down. Speedy trial means, when are you going to trial? Because let's say you get arrested and you hire me to represent you and you have court coming up, but I'm not ready because you just hired me. I don't have the evidence. I haven't spoken to the state. I haven't looked at your case. I want a continuance. I want to be prepared. I always tell my clients, you don't want to rush. Because rushing, guess what? You forget things, right? When you're rushing to get out the door and you're gathering everything and you hop in your car and you drive down the road, you're like, oh my gosh, I forgot my phone, because you were rushing and you weren't taking that time. Same thing with a criminal trial. Generally, a criminal trial involves your life, right? Are you going to prison? Are you going to jail? Is it a death penalty? So you want to make sure you take your time. So a speedy trial in the state of Florida is governed by the criminal rules of procedure. And it states specific time frames that you have to be brought to trial under certain categories of crimes. So let's say you've been charged with a misdemeanor. So you've been charged with a misdemeanor. The state has 90 days from the date of arrest or your notice to appear. In a misdemeanor, you can be mailed a notice to appear saying, hey, you need to appear in court on this date for an arraignment or pretrial conference. The state has 90 days to bring it to trial. Now you've hired me and it's the 75th day. Oh my gosh. I need to get familiar with the case. I need to look at the evidence. So I'm going to file a motion to continue. In that motion to continue, for the court to even consider that motion to continue, I need to waive my client's speedy trial rights, meaning, hey, My client waives his right to a speedy trial, meaning he waives his right to go to trial within that 90-day period because he knows that we need more time to get prepared. And the court will generally grant it with a waiver of speedy. And if I have to go in person in front of the court, I go, we'd like a continuance until the next hearing date. The judge will say, with a waiver of speedy? Yes, Your Honor, with a waiver of speedy. And so that means, okay, that 90 days has stopped. Now, what if I want to bring my case to trial? And I've only done this once, where I did a demand for speedy trial. So I did the demand for speedy trial when I knew that the victim, the alleged victim or the alleged witness in the case was actually in custody in jail up in Ocala on gun charges. So I knew that the state cannot bring that witness or that victim down to testify. So I immediately filed a request for speedy. And what that is saying, whoop, you got to bring us in. You got to bring us in and see where we're at. And we got to set a trial date. We got to set a trial date pretty quickly after that speedy trial. So and that hearing, that preliminary hearing has to be within so many days of filing that speedy trial. So I think I had filed that speedy trial on a Wednesday. The judge wanted to have the preliminary hearing on a Friday. I told him I just couldn't because I was bad time to file a speedy. I had to leave to go to a funeral. But I said, can we do it Monday? Because I'll be back Monday. He did. So Monday we show up, and I got to tell you this funny story. We show up Monday. I'm there. The judge is there. The state is there. Where's my client? My client is nowhere to be found. Your client needs to show up for a hearing on a speedy, on a demand for speedy. So we waited and we waited and we waited and we waited about 15 minutes. My client finally comes whoosh, flying in. My judge put him into custody. He ended up pleading out. Whatever. That's what we did. But the speedy, the demand for speedy is saying, okay, we're ready. We're ready. The defense is ready. Is the state ready? Are they ready to go to trial? If they were not. If they said, listen, we can't get our victim, we can't get our witness, he's in custody in another county or another state, we can't get him. The judge will look at the state and go, then what are you going to do? Because we're saying we're ready. We're ready to go to trial. Now, there can always be a continuance for exceptional circumstances or something, but they better have a good reason. Now, if they don't go to trial, they don't have any reason for an extension, any reason for an exception, anything like that. When you file that demand or you get close to those 90 days in a misdemeanor, we can ask for the case to be dismissed. If they're not ready to go to trial and we're ready and we're reaching our 90 days or we've requested a demand for speedy, we can request that the charges be dismissed because they need to be ready. If they're not ready and there's no reason to delay it, then we can always request that it be dismissed. Now, in felonies, which of course here in Florida are the more severe, it's 175 days from the date of arrest or notice to appear. So you have 90, a little less than a misdemeanor because that's a lower charge. Felony, 175 days. So that's what we call speedy trial. So it's not a fast trial. It's just a demand for speedy. So like I said, we can always waive our clients. I do oftentimes because maybe I don't have all the evidence, especially if it's a felony or a pretty severe felony. I want more time to go through the evidence. I want more time to go through it with my client. Maybe I'm trying to negotiate with the state on getting a good offer or an offer my client can live with. Those are always reasons for extensions and a reason to waive speedy on behalf of my client. So that is what speedy trial is called in the state of Florida. So moving from speedy trial on to the next thing. What was the other video that I talked about? This is a big thing in the United States because it's in the Constitution, right? Miranda rights. Your Miranda rights. What are Miranda rights? Let me take a little sip because this takes a lot of explaining. Miranda rights is named after a case, a seminal case, the United States Supreme Court, that said if a defendant, I don't like to call them defendants because then that gives them the title that they're automatically guilty. Let's say the alleged perpetrator. That sounds better to me. The alleged, I don't like defendant. The alleged person has been taken into a custodial interrogation or has been taken into custody. They've been handcuffed, put in the back of the car. They need to be read their Miranda rights. What is that? They have a right to remain silent. Anything they say can and you will be used against them in the court of law. You're entitled to an attorney. If you can't afford an attorney will be appointed to you by the court. So those are your Miranda rights. So it's always best, as I tell my clients, to no matter what, try to remain as quiet as you can, even if you're not in custody. Don't give out information. I cannot tell you how many of my clients have sat in front of me and have said, well, I thought if I didn't say anything, I'd be arrested. Well, look at, you're sitting in front of me. You were arrested. Now you're facing charges. So it would have been better for you to, rather than talk, and then you say something that, what I want to say, that implicates you or makes you sound guilty, even if you're not. You're just saying things. I had a client, he was trying to escape from the police. And as he was running or as he took off, he said, I don't want to go to jail. I've been in jail before. I want a bond, and I know I'm not going to get a bond. Now, they had read him his Mirandas when they originally took him into custody. So when he said that, it's a statement that could be used against him because he was read his Mirandas when he was taken into custody. So I felt for him. I feel for him because I know how he felt, but you can't run. So those Mirandas are very important because they protect your constitutional right to remain silent. You do not have to answer questions that the police ask you. You do not have to participate in any custodial interrogation. You do not. It is not a requirement. I know that you feel, even if you haven't done anything wrong, even if you're as innocent as a newborn baby, you still do not have to participate. So many people, so many clients that I get say, well, I didn't do anything wrong, and I wanted to tell them I didn't do anything wrong. But listen, the police are not your friends. If they've picked you up to question you, guess what? You're potentially a suspect. They're potentially going to ask you questions that are maybe not going to be more favorable to you. And the things that you say, you think you're saying them innocently and you think it's okay of what you're saying. But anything you say, if you're in a custodial interrogation and they read you your Mirandas, I had turned in one of my clients. It was a murder, and I think it was a murder. Yeah, it was a murder. And I came with him. I followed him. I brought him in. We turned him in. And immediately I said to the police, do not question him. He is not to be questioned. He is not to say anything. You are not to question him. You are not to talk to him. They brought him in the back without me. I told my client, don't say a word. They brought him in the interrogation room. They just sat him down. But then some other police officer, somebody came in and they wanted me to be brought in again so they could hear me say it. And I said, you are not to question my client. He will not participate in any custodial interrogation or any questioning. Do not ask him any questions. He is evoking his right to remain silent. And guess what? That's it. The police had to take him and, book him and do all that kind of stuff. They could not question him, as I stated. So they had to wash their hands and be done with it. So that is your right to remain silent. Now, in other countries, I don't know if you watch Netflix, there's a lot of Italian, shows and stuff overseas. And it sounds like when they read them, their version of Miranda's, that they're saying you have the right to remain silent, but know that your silence can be used against you. And I'm like, wow, that's crazy. So you're more or less forced to say stuff because if you remain silent, that could potentially be used against you. Not here in the US. They cannot use the fact that you did not communicate with them against you. For example, Donald Trump, who was just on trial for that hush money stuff. I guess there's closing arguments this week. I've lost track of it. But also, you have the right not to testify on your own behalf in a criminal case. So recall that when they came to the defense, and I think they called like one or two people, I don't remember who they called. But anyway, when the judge asked the defense attorney, Do you have any more witnesses? He stood up and said, no, I do not. Now, generally what happens, and they don't have cameras in that courtroom, the judge has to go through a soliloquy with the alleged person being charged with a criminal case and ask them, do you understand that you have the right to testify? Da, da, da. What is your decision? And if they decide not to testify, they say, I will not be testifying. Okay, that's it. Can't be used against them. The jury can't use that against him. So the jury can't say, oh, Donald Trump should have testified. He should have said this. He should have. No, it cannot be used against him in the jury deliberations, or even if it's a bench trial, meaning just the judge, in the judge's decision. Now, I get this question a lot. What if they continue to question me? Or what if they take me into custody and I haven't been read my Mirandas? Now, let's do that two ways. If they take you into interrogation and they're questioning you and you do not have the ability to leave. That's what having you in custody is. You cannot leave. So if you sit down in this interrogation room and you go, listen, I want to leave. I'm leaving. I'm done. Y'all can, deal with whatever you want to deal with. And they say, no, you can't leave. Now you're in a custodial interrogation. But if you have every right to leave, then you can leave. But if you can't leave it, they say, no, you can't leave. Then you're like, why can't I leave? Am I in a custodial interrogation? Am I in custody? Am I under arrest? Those kind of things. So they need to read you your Mirandas at that time. If you're not in custody or in custodial interrogation, they don't need. So if they're like, well, we're just asking some questions, but then that's why I'm always saying, you always got to say, okay, well, if you're just going to ask me questions, I want to leave. I'm done. But if they don't let you leave, that's when it crosses over. So if they don't read you your Mirandas and you're in custodial interrogation and you say something incriminating, as a defense attorney, we can file a motion to quash that statement, to cover that statement up, to get rid of that statement. And I don't think I've ever filed one myself, but I have seen them in court, and it's been very interesting as to when the police don't give those Mirandas and how the court reacts to that. Because the court gets very upset when they have to deal with that. You should have read the Mirandas. You should have done your job. Now we can't use this admission or anything that he said. Sorry, I get so allergies. Anyway. So you have to be in a custodial interrogation. So now let's say you're read your Mirandas, you're in the back of the car, and nobody is questioning you. The police officer, he's just driving, and you let out, and I've had this happen before. You let out this spontaneous statement. I did it. I'm so sorry. I didn't mean to do it. Can that be quashed? No, because the police didn't ask you a question. They're simply, and they read you your Mirandas. So they're driving. They're not asking you any questions. They're not doing anything. They're just driving you. And you spontaneously just let this admission out. Oh gosh, please don't do that. That can be used against you. I also get the question a lot. Well, I was in custody and they never read me my Mirandas. I should be let go. My first question is always, did you say anything? Did you say anything incriminating? If you didn't say anything, then no harm, no foul if they didn't read you your Mirandas. If they didn't read you your Mirandas, you stayed quiet, you stayed silent like you should, on the way to the jail, in the jail, all of that, then there's nothing to quash. There's nothing to, get out or anything like that. So there's no need to do a motion to quash because you didn't say anything, which was very smart on your half. So again, I want to reemphasize that. No matter what you do, I always want to direct you to please cooperate with the police, but don't give out more information than you should. They ask you a question, what's your name? They ask you where you live, things like that, but don't give more information than is required, because I'm telling you right now, they're not there for you. They're there to find out what's going on. And chances are they're going to use anything you say, and it's going to be put in a police report for everybody to see. So try to remain as quiet as you can, cooperate so you can get out of there quickly and deal with it as it comes. So that's Miranda rights. Miranda, I had a friend in law school. He had a t-shirt with the Miranda rights on it. It was so funny. I like him. He's really good. He still does criminal to this day. So I give him right. I give him kudos for that t-shirt. I'd love to have a t-shirt like that. And then I would emphasize the right to remain silent. That's what I would do. Anyway, okay, so we're done with Miranda rights. We're done with speedy trial. We're moving on to the what we call in Florida the 33-day rule. What is the 33-day rule? Doesn't that sound kind of perplexing to you, the 33-day rule? What is that? Well, when somebody is taken into custody, they're arrested, they're booked into jail, and there they are. Maybe there's no bond. Maybe they have a bond, but it's too high. They can't pay it. So they're sitting there in the jail, right? And have any charges been filed? Well, let's look. Nope, the state hasn't filed any charges, and they're sitting there and they're waiting and they're waiting. And there's no court date set because there's been no charges filed. So they're not going to set a court date until charges have been filed. So there they sit in the jail. Can they sit there forever? No. On the 30th day from the date of arrest and being in custody, I always mark it on my little calendar if my client's in custody. If there's no other type of holds, if they have an immigration hold or a hold for another county, that's a different story. But if they have no other holds and they've been sitting in that jail for 30 days and there's been absolutely no charges, criminal charges filed, whether it be an information or whatever it may be, an indictment, whatever it may be, that's when I file my 33-day rule. So if they've been there 30 days and no charges, and the 33rd day comes and still no charges, they need to be released. Now, that doesn't mean that charges can't come down the road, but they at least need to be released from jail. So the procedure that we do here in Florida is on that 30 day, I file my motion saying, hey, they need to be released. There's been no charges filed. Usually I do it by the 33rd day. And so what happens? I'm telling you, this is always what happens. The judicial assistant, when I send a courtesy copy to the judicial assistant with an order to release them, they always say, please check with the state about their position. Well, what do you think the state's going to do? What I've always happened is I do that. I do what I'm told. I check with the state attorney. Hey, as you're aware, I filed this 33-day motion and you haven't filed charges yet. So I've sent an order to the judge. What are we going to do? Sure as shoot, they seem to always file charges. All of a sudden they file charges and it's like, now we're kicked out of the 33-day rule because they've now filed charges. Now there's always, if there's some kind of reason, some extraordinary measures or something that, maybe there is this, it's a voluminous amount of evidence and they're still going through it, all of that kind of stuff. But for an extension of that 33-day rule. But if that's the case, and I'm going in and I'm filing motion for a bond because my client shouldn't have to sit there while you go through your evidence and you decide what you're going to do or what you're not going to do. When you took my client under arrest, you should have been more prepared to know what charges you're filing rather than just throwing them in jail. But knowing that sometimes they get arrested by the police and come on, you should be able to get it done by 33 days. I don't want my clients sitting there forever. And like I said, the 33-day rule comes into effect if there's no other holds. I get a lot of clients with immigration holds, so this doesn't really pertain to that because I'm always fearful and I go and talk to my client about what they want to do. Do you want me to file this 33-day motion, which I don't have a problem with? And sometimes it forces the hand of the state attorney to decide what they're going to do, if they're going to dismiss or what they're going to do, or they're going to file charges. But if they don't file charges and you're released, you could be held for immigration, and immigration could come and get you. And now I don't know where you are. You could be anywhere in the state. So, and then I can't resolve your criminal case, which I want to do. So I always talk to my clients about those different kind of issues that could come up in a 33-day motion or a 33-day hold. But what it does is it again, like I said, criminal procedures help move the case along. They move them along. And so if I didn't file the 33-day motion, my client could sit there for a very long time without charges filed, without anything. And potentially their case could be pushed in the back and nobody knows. But again, of course, I would file for some bond. Now, let me just point out a little special caveat to that, because in the 33-day motion, if charges are not filed, the individual has to be released immediately, ROR, released on recognizant, meaning they're just released. And like I said, that doesn't mean that charges could not come down the road. It just means they don't have to sit in jail and wait for those charges to be filed. So they can be released on their own recognizant. Charges could come later. Could they get rearrested? Yes, they could, depending on the charges. Or they just get a notice to appear, or I just get a notice to appear saying that, hey, they need to appear in court for a pretrial conference or whatever. So then we deal with it at that time. So that's the 33-day rule. So I've spoken a lot now about, speedy trial, about how we move cases along in that way. I've spoken about the Mirandas and how that can affect you. And then I've spoken about the 33-day rule, which again moves cases along. Now let's talk about the actual level of criminal offenses in the state of Florida. Now, every state in the United States is different, right? Our levels of crimes here in Florida are categorized by misdemeanors, felonies, life felonies, and capital felonies. Yes, in Florida, we do have the death penalty as an option, as well as prison time or jail time. So, but let's table that death penalty for a second, because I got a little opinion about the death penalty. Of course, that's my opinion. You can have your own. So, level of offenses in Florida, criminal offenses in Florida. Our lowest crime is what I call criminal traffic. Criminal traffic is, driving without a license, driving with a suspended license, a DUI potentially. That's a criminal traffic. Anything that is against the law as far as driving, right? I get a lot of no valid driver's license, meaning they've never had a driver's license, never, ever, ever had a driver's license. I've had as many as one individual having as many as 9 no valid driver's license. Now, the thing about a no valid driver's license, they can never what we call habitualize you, because it's a no, you never had one. So it just continues to be a criminal traffic. And yeah, you're probably going to face eventually some jail time. My guy with 9 the state was like offering like 60 days in jail. I got them down to 30. I went in front of the judge and got 20. That was the best I could do on a no valid driver's license, because it's pretty easy to prove that they didn't have a driver's license. So anyway, but it always remains in that criminal traffic realm. Now, driving on a suspended license, a suspended, revoked, expired, whatever, that's a little more serious. It's still in the criminal traffic area, but if you get too many, it now can become a felony, because you're habitualizing, you're doing it too much. They can do that. They can do it after the second, they can do it after the third, they can do it. I just had one that had her second, and they actually gave us pretrial diversion. I was pretty excited for her. But anyway, and then DUI, of course, is driving under the influence. Can be alcohol, drugs, whatever it is. Those are criminal traffic. So those are the lowest. They're usually fines, short time in jail, if you get jail, which I don't say you will get jail, but I do like to tell my clients their maximum exposure, not to say that they will get it. But the next level up of criminal offenses in Florida is misdemeanors. Let me take a break. Let me take a little drink break here. Misdemeanors are the next step up. Oh, look, Fabian, you have a question. Beautiful view, by the way, Fabian. I love it. Well, what are the consequences if the state fails to bring me to trial within the required time? Well, as we stated before, we can always ask that the charges be dismissed. Excellent question, though, because some people don't always realize that you can ask for the charges to be dismissed if they don't bring you to trial in the allotted time. Either you do a demand for speedy, or you never waived your speedy to begin with. They need to be ready. Everybody needs to be ready when that speedy time comes up. So excellent question, Fabian. Thank you. And I hope you're having a nice time on the beach, by the way. Anyway, misdemeanors. Misdemeanors are the next level up. They're not as bad as felonies, but they're getting there. They're kind of on the building block. Now, with misdemeanors, there are second degree and first degree. That's all. Second degree misdemeanor and first degree. And so the second degree misdemeanor is only punishable by up to 60 days in jail, a $500 fine, or both. That's generally what your maximum exposure is. And some examples of some misdemeanors here in the state of Florida are like, disorderly conduct, petty theft. Petty theft is the taking of anything of value of less than $750 here in the state of Florida. And then, simple assault or anything. Those are generally second degree misdemeanors, punishable by a maximum of 60 days. Now, generally, I can get, probation or pretrial diversion or whatever, on a second degree misdemeanor. That's the lighter of the two. What do I want to say? That's least the smallest misdemeanor. It's funny because misdemeanors in Florida, the higher the number, the lower the level. In felonies, the higher the number, the lower. So it all works out. But the first degree misdemeanor is up to 1 year in jail and a $1,000 fine, or both. That's your maximum exposure. And stuff that fit into that first degree misdemeanor, even though it's criminal traffic, is DUI, first offense, domestic violence without serious injury or without strangulation, domestic violence, battery. You hit each other, you've got marks on you or whatever. A battery, domestic violence is generally a first degree misdemeanor as long as there's no serious bodily injury, no strangulation, no weapons used, anything like that. And the maximum, again, is up to 1 year in jail and a $1,000 fine. Of course, like I said, there's always negotiation. There may be probation, pretrial diversion if it's your first time, maybe a batterer's intervention course. Let me tell you, those battery domestic violence, there always comes with it a battery course. 26 weeks. 26 weeks, once a week. My clients have to go to that. Now, it's better than jail. I give you that much. It is better than jail, but 26 weeks. It's an intense program. So those are misdemeanors. Those are our lesser crimes. Now, battery domestic violence, we call it a battery DV. If you get too many, again, you can be habitualized and they can turn into felonies. So you got to watch it. So I keep talking about felonies. Let's go into felonies. Felonies are the more serious offenses here in Florida with harsher punishments or harsher penalties. So generally they require, now if you're going to spend less than 365 days plus one in custody as a punishment, they'll generally keep you in jail. The Orange County Jail, Seminole County Jail. If you're going to spend 365 days plus two, they're going to send you to receiving facility or to prison because that's what you're looking at. So the lowest form of a felony is the third degree felony. That's the lowest. That's punishable by a maximum of 5 years in prison and a $5,000 fine. So what does that include? Some examples are grand theft, meaning taking of property of value more than $751 and up is a grand theft. There is possession of a controlled substance. Cocaine, heroin, depends on how much you have. It could bump it up to a second or even a first, but possession of a controlled substance, maybe battery on a law enforcement officer, a LEO, we call it, law enforcement officer. So that's the maximum. I generally, with the third degree felony, depending on what their criminal record is, depending on what they score, we have a score sheet here in the state of Florida, I try to keep them out of prison. I try to keep them out of jail. Hopefully I can do that with negotiations with the state. Okay, the next degree, let's climb up the ladder. We're going up to a second degree felony. A second degree felony is punishable by up to 15 years in prison and a $10,000 fine. Again, maximum exposure. maximum exposure. I'm not telling you you're getting that. I'm telling you that's what your maximum exposure. What does it mean when I say maximum exposure? It means you go to trial, you're found guilty. That's the maximum the judge could give you. I'm not saying the judge would give you the maximum. It's up to the judge. But anyway, things that are crimes that are fit into that second degree felony is aggravated battery. People always, what is aggravated battery? Let me see. What do I have here? What do I have here? Oh, this is a good thing. My stapler. If I hit you with this stapler, that's an aggravated battery. I used a weapon. Although you think it's a stapler. Really? It's not a weapon. It can be used as a weapon. It's hard, it's strong, it can cause serious bodily injury. So this stapler could fly me into aggravated battery. Burglary of a dwelling. What is burglary of a dwelling? The entering of a dwelling without consent with the intent to commit a felony therein. What is a felony? I'm stealing stuff. I'm doing something. Whatever I'm doing in there, I shouldn't be doing. So burglary of a dwelling, child abuse, those are things that drop you into that second degree felony. So again, second degree, 15 years in prison, $10,000 fine. Oh, I have another. Oh, Melissa, I'm telling you, you guys have the best pictures. My pictures, on Facebook are okay. Do Miranda rights apply to all types of questioning by police? Well, again, good question, Melissa. Custodial interrogation. You have to be in custody. You have to not have the right to leave. Hey, I want to leave. I want to get out of here. Hey, I don't want to talk to you people anymore. No, I'm sorry. You can't leave. You can't leave. Hey, am I in custody? Am I in custody? No, am I in a custodial interrogation? If I'm in custody, I have the right to have my Mirandas, because why am I not allowed to leave? If I'm not in custody, if I'm not under arrest, if you don't need me, then why? Why? If I'm a witness, maybe they'll be like, okay, well, here, I want to go. I want to go home. I want to go home to my family. If you need anything from me, here's my contact, or here's my attorney's contact. You can just reach out to them. But I don't want to be involved with this. So I don't want to be involved with this right now because I don't want to say anything that might harm me in any way. So good question, Melissa. You look like you're having a lot of fun. Okay. Oh, Luciano. Oh, my goodness. Oh, that's another nice picture. You all have nice pictures. Thank you for your show. I have a question. What constitutes good cause? Let me move my little thing here. For extending the period beyond the 30 days. Oh, what you're saying for the 33-day rule? Good question. Maybe, like I said, it's a big case. It's a big murder case, and they still haven't gotten all the evidence, and they want to make sure they get it all. Or I don't know, maybe the courts were closed or something, or COVID was crazy. I just want to point that out. My poor criminal clients, it was crazy trying to get these people into court. It was just unbelievable, but we got it through and we made it through, thank God. So very good question. So if there is good cause, the court can extend it, but I'm still going in and asking my client to be released, because that's just, to me, 33 days is way too long to be sitting there waiting for somebody to make up their mind. So good question, Luciano. Thank you so much. Okay, we're climbing the ladder. We're almost to the top. We're on felonies still. I'm climbing another step. I've now made it to first degree felonies. So that's up to 30 years in prison or life. Sometimes there's life felonies. We call those PBLs, punishable by life. So, and a $10,000 fine, or both. Examples of a first degree felony: kidnapping. Kidnapping doesn't just mean you go snatch a kid. That isn't what it means. It could be that you're not allowing somebody to leave by force. There's false imprisonment and there's kidnapping. False imprisonment can be a misdemeanor. Kidnapping is a felony. So where you're by force keeping somebody, or you snatch somebody, like you hear people being taken and all those kind of things. Kidnapping. By the way, a little FYI, parent can't kidnap a child. He kidnapped, he came to my house, took the child without my permission. Now, if they take him to another country and refuse to return him, that's a whole nother ballgame. That's a whole nother life, right? Sexual battery of a child can be. Now, sexual battery, that's another term we use in the state of Florida for rape. Sexual battery has replaced rape. Now, sexual battery of a child that is over the age of 12 is a life felony. First degree felony would be, a sexual battery without aggravating circumstances, meaning not a child, but an adult. So that can be a first degree felony that's punishable up to 30 years in prison. Now, that's not, you would think I'm done, right? 3 felonies, I'm done. No, 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 no. I have another ladder. Ooh, and you know what? I don't like ladders. So, I'm going up the ladder though for you all. Life felony is a PBL, punishable by life. Life in the state of Florida is just that. You do not get out. There's no parole. There's no nothing like that, unless I guess the governor came and pardoned you or something. I don't know. I don't know. In the how many years I've been here in Florida, I've never known that, but I could be wrong. But a life felony is just that, punishable by life, PBL. And some examples of that, again, is kidnapping by force, sexual battery on a child under the age of 12. And I'll describe that again when I talk about the next realm I'm going up. Human trafficking, all that are life felonies. So let's go up and punishable by life. Done over life imprisonment, you go. I had a judge one time tell my client it was a murder case and it was a capital, and I'll get into capital in a moment. And we got him 30 years, better than life in the state of Florida, because life, you're never getting out. At least he'll get out. And the judge said to him, you better be happy, because if you had gone to trial and been found guilty, I would have put you in prison for life. And you know what that means? That means you're not coming out until you're coming out in a box. That's all I did was shake my head. That was not necessary, but it's okay. It was, my client fully understood that, and that's why he took the deal. So he fully knew that that's what would have happened. So now let's go up that final ring, capital felonies. Capital felonies is not just life imprisonment, but could be the death penalty. Yes, we have the death penalty here in Florida. We have for a very long time. Now, it's gone back and forth a couple times about how the death penalty is initiated on somebody. Obviously, the state has to say, we're going after the death penalty. They have to alert you on that right away. Now, when you go to trial, and let's say you're found guilty, okay, capital felony is murder. Intent murder, first degree murder. You're found guilty and the death penalty is on the table. Now you have to go through the sentencing phase. And that's where, as a defense attorney, we can bring mitigation. Oh, just thundered. We can bring mitigation. And so that mitigation is to keep our client alive, to have them put in for life, not have them be on death row. So with the death penalty, it used to be, it could be 8 people could, on the jury of 12, find that the death penalty, and the judge could recommend death. Then it was changed to, it had to be unanimous. Right? And then they had this shooting, I can't remember, down south, and he pled out to being guilty. The shooter in that case, he pled out, but they had to have a sentencing phase as to whether he got life or death. So at that time, the jury couldn't come to a unanimous decision on death. So he was given life in prison. And so then the legislator went to work, and Governor DeSantis signed right off that now it's back to 8. Only has to be 8 people to decide the death penalty in a sentencing phase for you to get the death penalty. If you've committed, like I said, first degree murder, first degree is premeditated. And from law school, premeditated can be just for a second. It doesn't have to be like you've been planning it for days. It can be just that split second. Capital sexual battery, which is sexual battery on a child under the age of 12. That's a capital. Now, let me tell you a little secret. That just used to be life in prison. That would be a PBL. But now, guess what? Governor DeSantis signed in the law that now capital sexual battery, meaning sexual battery on a child under the age of 12, can face the death penalty. I don't agree with that. That's my opinion. I don't agree with that, but it's the law now. They actually have a gentleman that in Lake County where he sexually battered a child under the age of 12, and the state has announced they're seeking the death penalty. I don't agree with that. I understand it, but I don't agree with it. The aggravating circumstances should be sexual battery of a child under the age of 12 that resulted in a death. That's what capital is for. That's what it should cover. It should not cover these sexual batteries. They should span, okay, if it's proven and they're found guilty, okay, life, I understand that. But the death penalty, I just don't see what the point of that is. Anyway, oh, Candela, everybody's at the beach. What's going on? Anyway, does a capital offense require the death penalty in Florida? It does not always. Good question, Candela. It doesn't always. Just because first degree murder occurred doesn't necessarily mean the death penalty, that the state has to go after the death penalty on with that. I'm trying to keep track of my time. I don't want to, I'm respectful of everybody's time, so I want to make sure I finish on time. But they do not have to go after the death penalty. My client, it was a co-defendant. It was a co-defendant. There were two of them. The first one went on trial. He was found guilty. The death penalty he was the shooter. The death penalty wasn't on the table for whatever reason. I don't know. It wasn't my case. It doesn't concern me, but he got life in prison. My client, who was the co-defendant on the case, the death penalty wasn't on the table because and I know why, because he wasn't the shooter. He was there, he participated, he committed a felony in the commission of it, so I understand it. Why they didn't put the death penalty on the table? They could have, I guess. I don't think they would have gotten it, but who am I to say? But if he had gone to trial and found guilty, he would have been life in prison. So no, they don't always. It does not always mean the death penalty. I think the state really looks at the cases and says, okay, what happened here? What were the circumstances? How severe? How awful? How terrible? The shooting down south. Horrific. Every time I watch the documentary, I cry like a baby. They went after the death penalty there because of those circumstances, and he ended up getting life. So good question, Candela. Thank you so much. All right, we're coming to an end because I want to be respectful of your time. I want to make sure that you got all the information. Remember, if you don't live in the state of Florida, please, please, please get with an attorney in your area, your state, so you can find out what the rules are in your state, especially if you're facing some criminal charges or if you've been arrested. And please, my advice to you as well, don't give up so much information. I call it vomit information. Don't vomit all this information to the police if you're stopped or if you're arrested. You have the right to remain silent. Don't think, well, I'm going to talk because I'm going to be able to talk my way out of it. You will not. It's going to look bad on a police report. It's going to look bad on the body cam that they may have. It's just going to look bad. So make sure you say, I don't want to say anything. I want to talk to my attorney. I want to talk to an attorney. I want to talk to a attorney. I don't want to say anything. And they have to back off. They have to, I know you see on movies and stuff, they don't, but that's that, if they continue to question you after you've said, hey, I'm invoking my Mirandas. I want the right to remain silent. I want to talk to my attorney, and they continue to question you. Bad, bad, bad. Boop, boop, boop. Out goes all your statements, because I'm going to run in with emotion so hot off the presses, it's going to be on fire. Anyway, what I wanted to also tell you, thank you so much for tuning in. Next month, the month of June, the beautiful month of June, I'm going to have my live on June 25th at 2:00. We're going to talk about battery, the different levels of battery, domestic battery, sexual battery, just regular old battery when you're beating up your neighbor or whatever you're doing. We're going to talk about that for the month of June. So that'll be a nice hot topic to find out all about that and the punishments that are associated with them and what the courts look at as far as aggravating factors. So it was a pleasure spending the last hour with you. I hope you got a lot out of this. Remember, if you have any questions or any concerns that you want to ask me, we're here for you. Please feel free to reach out either by my Facebook, phone call. We'd love to hear from you, and we'd love to help you out and protect your constitutional rights here in the United States and here in the state of Florida. Have a beautiful, beautiful day, and I see you next month.